Good afternoon, but also good morning and good evening to everyone joining us today. I'm Roberta Solis, the Judicial Integrity Team Leader at UNODC's Global Program for the Implementation of the Doha Declaration, which acts as the Secretariat of the Global Judicial Integrity Network, a platform of judges and for judges to provide support in strengthening judicial integrity worldwide. It is our pleasure to welcome you in the third webinar of the series organized by the network on the priority topics identified by its participants and that constitute new challenges for judges and jurisdictions across regions. With this initiative, we aim to continue to broaden the opportunities within the network for networking and knowledge exchange, in particular during this time in which it's very difficult for courts and institutions to organize in-person sessions. Before introducing our lecturer of today, I would like to give the floor to the coordinator of the Global Program for the Implementation of the Doha Declaration, Mr. Marco Teixeira, who would also like to greet the audience of our webinar. Marco, the floor is yours.
Thank you, Roberta, and it's my pleasure to welcome you all for this third webinar of the Global Judicial Integrity Network. I see some of you from different parts of the world, so it's our pleasure to welcome you and also to appreciate that you share your time with us also in these important topics. And of course, this shows your commitment on strengthening globally judicial integrity. I would like to begin to stress the importance of this topic and a special appreciation to Justice Jones for being with us today and made herself available to share her expertise and her judicial knowledge. As you might be aware, the Sustainable Development Goal number 5, it's clearly linked with pursuing gender equality, and Sustainable Development Goals are closely linked, and therefore it is not possible to achieve peace, justice, and stronger institutions, basically the SDG 16, without mainstreaming gender. At this time, effective, accountable, and inclusive institutions are of critical importance to achieve gender equality and, I would say, more broader sustainable development by enabling also women to access to justice. I would like also to mention that since 2018, UNODC Gender Equality Strategy has guided our efforts, and it was because of this context that our global program has mainstreamed human rights and gender-related issues in alignment with UNODC mandates in the areas of justice. We focus our efforts on fulfilling SDG 5, gender equality, by carrying out raising awareness activities about gender-related integrity topics, also within not only the judicial sector, but also in the educational sector, prison setting, and sports-related also environments in a holistic approach that we have. In a very concrete example of our impact as a program, I would like to mention that 51% of our beneficiaries are female, which means 49% are male, so a very balanced approach. And also 60% of my colleagues that work in the program are female colleagues. Of course, besides these quantitative metrics, gender perspectives are promoted also in the preparation and design of our activities and also publications and tools. And I think judicial integrity component that Roberta leads is a good example of the way that we integrate gender in our work. In particular, I would like to mention also that gender-related judicial integrity issues, since the launching of the network, are being seen as a topic priority for the network's work plan. And also it was a recognition that gender plays a role in integrity of judicial conduct, in courts administration, and also public perceptions of the judiciary. Finally, I would like to thank you again for your commitment to share your time with us, also to attend this series of webinars from judges to judges, and I hope this interesting webinar will serve also as an enabler to continue to foster gender equality, because this is also important inside of the judicial system. So thank you very much for being with us, and Roberta, over to you.
Thank you very much, Marco, as usual, for your support. For everyone joining us today, in today's webinar, we'll explore the topic of training to eliminate gender bias and stereotype during the adjudicatory process. Gender biases and cultural stereotypes, even if they are unconscious, pose a threat to judicial integrity and the fairness of judicial decisions. Over the years, judicial training has proven to be an integral element in combating gender bias and stereotype. by affecting behavioral change, and in doing so, it helps to promote effective access to justice and to enhance confidence in judges and judicial institutions. We have received many positive comments from the participants of the high-level meeting of the network last February in Doha, Qatar, about the session on gender-related integrity issues and on how participants would have loved to have more time at the end of the session to ask questions about gender bias and judicial education. So we thought that it would be a good idea to continue this discussion through our series of webinars. For all of that, we are delighted to have with us today Justice Judith Jones and learn during this lecture from her extensive judicial career, first with 11 years in the High Court bench and now in the Court of Appeals of Trinidad and Tobago, and one of the first jurisdictions in the world to have adopted a gender equality protocol for judicial officers as a practical guide geared towards fostering gender-sensitive adjudication. She has also an extensive experience as a judicial educator at the Judicial Education Institute of Trinidad and Tobago and a fellow of the Commonwealth Judicial Education Institute. Welcome, Justice Jones, if I may, Judith, and thank you very much for being with us today. Before I pass the floor to you, just one last quick reminder to all of the participants. Please keep your microphones muted during the webinar. If you have questions for Justice Jones, you can ask them using the chat service here in this platform. Judith, the floor is yours. Thank you very much for being with us today.
Thank you. Good morning. All right, good. I want to thank the Global Judicial Integrity Network for inviting me to be a part of its webinar series. As you can see, I'm very excited to be here. And I want to thank you for inviting me into your homes or your offices or just your countries. This series provides a unique and cost-effective opportunity for us as sitting judges to network and share ideas. I hope that this initiative will continue long after we have conquered this dratted virus. Our topic today is eliminating gender biases and gender stereotypes during the adjudicatory process. It treats with avoiding gender discrimination in our decision-making. For the purpose of our discussion today, I will be using the words judge or judicial officers interchangeably to refer to members of the higher and lower judiciary. Spoiler alert, at some times I will be referring to a few of my experiences. This is not because I think my experiences are unique, on the contrary, but it is simply because it is what I know and can speak of with some semblance of authority. Bear with me. As a group, we are very diverse. We have more differences than things in common. However, no matter how dissimilar we are, there are a few basic things that we all have in common. As we have recently discovered, we are all prey to this novel coronavirus. But more to the point, we are all professional judges. And in keeping with our topic today, we all have a sex and we all ascribe to a gender. While this is not the forum to get into a lengthy discussion on the differences between sex and gender, it is important to bear in mind that there is a difference. Simply put, sex is biological, while gender is a social construct and therefore fluid. You will see on the screen the definition of gender published by UN Women. Gender refers to the roles, behaviors, activities, and attributes that a given society at a given time considers appropriate for men and women, in addition to the social attributes and opportunities associated with being male and female, and to the relationship between men and women, girls and boys. Gender also refers to the relations between women and those between men. These attributes, opportunities, and relationships are socially constructed and are learned through socialization processes. They are context and time-specific and changeable. Gender determines what is expected, allowed, and valued in a woman or a man in a given context. The roles and characteristics associated with a particular gender change from society with a particular gender change from society to society and over periods of time. To illustrate the point, have a look at this photograph. If we were asked to name this picture, we would name it Picture of a Young Girl Sitting and Staring. That is what it looks like to most of us. In fact, it is a picture of the American President Franklin D. Roosevelt at age 5 or 6. In the 1880s, it was quite normal for young boys to be dressed this way. The characteristics determined by a society to relate to a particular sex can change over time. The very fact that gender attributes change from time to time and from society to society requires us as judges to be aware of these changes. Little boys no longer look like young Roosevelt. Women are no longer confined to the home. In Trinidad and Tobago, where I live and work, when I left law school, there were no more than a handful of women in private practice. There were about 3 women in the lower judiciary and no women in the higher judiciary. Now, 70% of our graduates are from law school are women. At each level of the judiciary, with the exception of the Court of Appeal, women outnumber men. By the looks of it, that will soon end. At present, our Court of Appeal comprises 6 women and 9 men. In today's world, there's such a thing as stay-at-home dads. We didn't know about that in our time. In some of our jurisdictions, same-sex couples can marry and raise children. The world is coming to terms with the fact that sex is no longer simply male and female. As the world changes, norms change, and the roles, attributes, and characteristics that once used to define the genders are constantly being questioned and challenged. As judicial officers, we are duty-bound to recognize these changes and give effect to them in our adjudication. Once we as judicial officers accept that one of the sources of judicial power is the acceptance by the public of the moral authority and integrity of the judiciary, that it is our responsibility to ensure that our decisions accurately reflect life's reality, lest we become irrelevant. As professional judges, we ought not only to be concerned with whether our judgments are correct in law and whether they can withstand the appeal process, we ought also to be concerned with justice, doing right by those persons whom we serve. Maintaining the relevance of the judicial system apart, there's another equally fundamental reason for eliminating gender bias in our adjudication. As professional judges, no matter where in the world we sit, whether we preside in civil or a common law jurisdiction, we all ascribe to the Bangalore principles of judicial conduct. I will be referring to this throughout the discussion as the principles. These principles establish standards for judicial conduct throughout the world. They require us to adhere to 6 core values. The 6 core values are independence, impartiality, integrity, propriety, equality, and competence and diligence. Of particular relevance to us today are the values of impartiality and equality. Both of these values require us to examine not only the decisions arrived at by us, but the process used in arriving at our decisions. Impartiality. And this is from the principles. The principle is impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but also to the process by which the decision is made. And one of the applications refers directly to the question of bias and prejudice. A judge shall perform his or her judicial duties without favor, bias, or prejudice. equality. It is ensuring equality of treatment to all before the, ensuring equality of treatment to all before the courts is essential to the due performance of the judicial office. A judge shall be aware of and understand diversity in society and the differences arising from various sources, including but not limited to race, color, sex, religion, national origin, caste, disability, age, marital status, sexual orientation, social and economic status, and other like causes, otherwise known as referred to as irrelevant grounds. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice towards any person or group on irrelevant grounds. A judge shall carry out judicial duties with appropriate consideration for all persons, such as the parties, witnesses, lawyers, court staff, and judicial colleagues, without differentiation on any irrelevant ground, immaterial to the proper performance of such duties. A judge shall not knowingly permit court staff or others subject to the judge's influence, direction, or control to differentiate between persons concerned in a matter before the judge on any irrelevant ground. A judge shall require lawyers in proceedings before the court to refrain from manifesting by words or conduct bias or prejudice based on irrelevant grounds, except such as are legally relevant to an issue in proceedings and may be the subject of legitimate advocacy. The commentary accompanying this value reminds us that it is a duty of a judicial officer to discharge his or her judicial functions with due respect for the principle of equal treatment of the parties, by avoiding bias or discrimination and by maintaining a balance between the parties and ensuring that each receives a fair hearing. It particularly enjoins us to avoid stereotyping and gender discrimination. Gender biases and reliance on gender stereotyping in our adjudication facilitates and encourages gender discrimination and gender partiality. It prevents us from achieving true equality of treatment, and in doing so alienates members of the public and erodes confidence in the judicial system. We all have biases. Let's face it, we all have gender biases. Let us use the game show to demonstrate. When we look at a game show on television, we invariably choose one contestant to support over the others. This is usually done within the first few minutes of the show, sometimes even before we are given any information about the contestant other than a name. Why do we do that? And more importantly, what do we use to differentiate between them? How do we choose which contestant to support? They are all perfectly viable options. The next time you look at a game show, examine why you choose to support that contestant over the others. What does your choice tell you about your instinctive biases? Sometimes, oftentimes, it is as simple as choosing the contestant that looks most like us. Sometimes it is not that simple. There's nothing wrong with this behavior. In fact, it is what we are expected to do. It makes the game show more enjoyable. For judicial officers, the problem arises when we bring those biases into our professional lives and leave them unchecked. Social science research tells us that we all have two systems of cognition, intuition and reasoning. Intuition decision-making is fast, highly contextualized, socialized, and personalized. Reasoning is more time-consuming, conscious, rule-based, analytical, and demanding of cognitive capacity. If we were all asked the question, we would all say that as judicial officers, we always use reasoning to come to our decisions. But do we really do that? When we have to make a decision, our natural inclination is to go with our intuition. The research suggests that the more objective we believe ourselves to be, the more likely we are to act on our biases and overestimate our invulnerability to them. When time is a factor, and as judicial officers, we know that time is always a factor, the tendency is to stay with this natural inclination. So too with the use of stereotypes. In some, but not all, instances, this intuitive thinking may be reinforced by stereotyping. Sometimes, however, rather than the intuitive thinking being reinforced by the stereotype, it is a stereotype that influences our intuitive thinking. Stereotypes are very dangerous things. Generally speaking, a bias describes a personal preference, a like or dislike. A stereotype, on the other hand, is a preconceived, usually widely held idea attributing a characteristics or characteristics in general to members of a class. It is often couched as a generalization. For example, blondes are dumb, or black people have rhythm. It often, but not always, has negative connotations. A gender bias is a personal preference, a like or dislike based on gender. Gender stereotypes are generalizations about the gender attributes, differences, and roles ascribed by society to the different genders. Gender stereotypes can vary from society to society, but generally we stereotypically think of men as strong and brave and women as soft and weak. The use of stereotypes is one of the mechanisms adopted by our minds to process the huge amounts of information that we are bombarded with on a daily basis. Sometimes these generalizations are the product of our personal experience. For example, we may, as a result of our personal experience, genuinely believe that all blonde persons are stupid, or that all black people have rhythm, or that women are by nature carers. Or it could be the product of years of conditioning transmitted to us by bedtime stories, films, the media, etc. Sometimes, most times, these feed one upon the other, and it is difficult to separate the two. In other words, did that black person really have rhythm? Or is my assumption that the stereotype was true color my perception? Are women naturally carers? Or is it as a result of conditioning, our conditioning, or their conditioning? Some stereotypes are so inculcated in us that even when they run contrary to our personal inclination or biases, they still operate on our minds and we accept them as truths. So that even if our natural inclination is towards women, if we have a bias towards women, we may still genuinely believe that men are leaders and women followers. And if we had to make a decision in this regard between an equally qualified woman and a man, choose the man. We've heard things like, she's qualified, but I'm not sure of her leadership capability. The truth is that we all buy into stereotypes, no matter what our gender. Even stereotypes that have the effect of belittling our gender. So it would not be strange to hear a woman say, for example, that they don't have female friends because women like to gossip. Gender discrimination occurs in adjudication when we act on our biases or fail to appreciate or be sensitive to the different perspectives of men and women, or allow gender stereotypes to affect the way we think and make decisions. In 2016, the Bangkok General Guidance for Judges Applying a Gender Perspective in Southeast Asia was published. It lists some common stereotypes that judges ought to avoid in adjudication. Women are physically weak. Women cannot make decisions on their own. Men are the head of the household and must make all the decisions related to family. Women should be submissive and obedient. Good women are sexually chaste. Every woman wants to be a mother. Women should be the ones in charge of their children. Being alone at night or wearing certain clothes make women responsible for being attacked. Women are emotional and often overreact or dramatize. Hence, it is necessary to corroborate their testimony. Testimonial evidence provided by women who are sexually active may be suspect when assessing consent in sexual offences cases. And lack of physical harm in sexual offences cases means consent was given. Sounds familiar? Do we unconsciously buy into some, if not all of them? There are many others. My purpose here today is not to provide a list of stereotypes that we as judicial officers should avoid, nor is it to tell you how to determine the cases before you. It is simply to give you some tools that may assist in making your decisions free of gender discrimination and accord with the values of impartiality and equality of treatment as demanded by the principles. So, how do we do this? I have devised some tips. They are divided into 4 general areas: self-examination, the process, the outcome, and training. The first step in self-examination is acknowledging that we have biases. This calls for introspection. The point here is for us to recognize that our decisions initially come from that instinctive place referred to earlier, and that, unless checked, they remain there. There are many tests aimed at demonstrating that we all have implicit or instinctive biases. I personally like the implicit bias test conducted by Harvard University. I have done one or the other of the tests contained there over a period of years. The results never cease to amaze me. Taking the tests serves to remind me that however open-minded and bias-free I think I am, I still engage in instinctive thinking. It is still my go-to position. Do the test. Treat it as a reality check. You will find the address for the website in the bibliography screen that will be shown at the end of this discussion. How have I dealt with gender issues in the past? This is a little more difficult. Look at your track record. It will give you an insight on your public face. Have I in the past shown a bias or personal preference towards or against a particular sex or gender? Look at your past decisions. Is there a trend? Unfortunately, it is not always possible to answer these questions by simply examining your past decisions, or where there has been an appeal, authoritative comments made on your judgments by other judges. Case in point. Early in my legal practice, I represented trade unions in the industrial court. In that court, lawyers were optional. One of the judges, the president of the court, held the opinion that women lawyers had no place in the industrial arena. In fact, it may have been a combination of 2 biases, one against lawyers and the other against women. I will never know. At that time, the distinction had no relevance to me. Appearing in his court was a constant battle. However, luckily for me and my clients, As was the position with trade unions at that time, my clients were mainly men. So his gender bias against women lawyers was not reflected in his decisions. The very real gender discrimination that I felt was not reflected in any way which would allow me to obtain any redress, not even by way of appeal. So it is sometimes with the litigants who appear before us. The takeaway point from this story is that many times there may be no challenge to the soundness of your decision. Your record on review of your judgment may be perfect, but unfortunately, that alone does not make you a good judge. Let us look again at value 5 and particularly 5.2 and 5.3 of the principles. Not moving. Oh. Done, all right? Both. In similar vein, where the issue at hand involves the exercise of a discretion by a judge, it may be difficult to identify a gender bias unless the judge's behavior is blatant. In the common law jurisdiction, a court of appeal will only interfere with the exercise of a discretion by a trial judge where it can be shown that the judge was plainly wrong. As a result, it is only in gross and obvious cases that a judge will be called out on the basis of a gender bias. The point I make here is that it is not always possible to identify a gender bias from examining the decision in the case, and even more difficult to challenge it. So where else can we get empirical evidence as to whether we have shown a gender bias in the past? Where transcripts are available, examine them. You don't have to examine every transcript, but there will be a case or cases where you're not sure, where you suspect that something went wrong. And while examining the transcripts, ask yourself the question, does my behavior here reveal a personal preference, a like or dislike towards or against a particular gender? You won't be able to do anything about those cases that have gone, but the exercise will put you on guard for future cases. Remember that even where your decision is not appealable or likely to be overturned on appeal, attorneys who appear before you regularly generally have a fair and accurate idea of the type of judge you are from your behavior in court and your decisions. Attorneys know and they talk. It gives life to the words, your reputation precedes you. Is this a case likely to trigger any gender bias? When a case is assigned to you, ask yourself these questions. Is this a case that is likely to trigger any gender bias? Is this a case where gender is an issue? Are the roles, behavior, and attributes expected of a particular sex of importance in this case? Is this a case where the sexes are pitted against each other? Typically, where the sexes are locked in dispute, when the case concerns a relationship between sexes, gender is an issue. In these circumstances, our instinctive gender bias is more likely to be triggered. This doesn't mean that these are the only cases in which gender bias and stereotyping rear their ugly heads. But it is more likely that these are the cases which trigger an instinctive reaction in you. These are the red flags that will put you on your guard. The process. Responsibility for staff. In dealing with the value of equality, the commentary to the principles reminds us that we have a duty to ensure that court staff conform to prescribed standards. Consider this situation. When I was first appointed to the bench, while doing trials, I would notice through the glass door to the court that after requesting a witness to be called, my court orderly would go outside. I would see the witness approaching the door, then have a short conversation with my orderly, then step out of my sight. After a few minutes, the witness would return and be escorted into court by my orderly. After a few such occasions, and mainly because I was annoyed by the delay it was causing, I asked my orderly what was happening, only to discover that she was telling all male witnesses with shirts not tucked into their pants to step aside and tuck their shirts in their pants before coming into court. No such request was being made of female witnesses, and I had given no such instructions. But now I was involved in gender discrimination that had implications in access to justice. I give this example only to show how important it is for us to be aware of the actions of the court personnel for whom we are responsible, and to ensure that they are provided with the appropriate training. Court witnesses. This is an issue that has arisen in custody proceedings, but I imagine it is not only relevant to custody and access applications, but may arise in other proceedings. In these proceedings, it is not unusual for a judge to seek assistance from experts such as psychiatrists or psychologists, or reports on welfare or probation officers. In the common law jurisdiction, the general position with this evidence is that while the judge is not bound to accept the recommendations, they are usually accepted unless there are valid reasons to depart from them. And if there are valid reasons for departing from the recommendations, the judge is required to give reasons for such departure. Before placing reliance on the advice and recommendations given by these professional witnesses, we should always carefully examine the evidence to ascertain whether the advice or recommendations were made on the basis of the officer's or expert's personal gender bias or as a result of stereotyping. It is not unusual for recommendations to be made based on the officer's personal biases. For example, I have seen reports which give more weight or credit to the father's effort in caring for the child, simply because it does not accord with the common stereotype that it is the mother's responsibility to care for the child. The effect of this is to devalue the mother's care for the child and enhance that of the father's, simply because it runs contrary to a common stereotype. It is our duty as judicial officers to call out these persons who make recommendations to the court under the guise of expert evidence based on personal biases or stereotypes. Cross-examination. Although important in all cases where the issue is gender-based violence, this is particularly important where the proceedings are held before a jury. It is important for judicial officers to protect the process by ensuring that cross-examination that serves no useful purpose and simply serves to traumatize the complainant is prevented. Remember, we are in charge of the evidence placed before the court. Further, the principles provide for us to have a responsibility with respect to unwelcome cross-examination. You have the thing. And cross-examination that tends to traumatize the witness. Directions to the jury. Although it is now standard practice for directions to the jury to contain warnings to the jury about relying on stereotypes, it is worth repeating here that the jury must be warned about such reliance, particularly because these may be stereotypes that we as judges in fact believe. the outcome. Before arriving at your decision, deliberately move from instinct to reasoning. This may involve taking a little time out before giving your decision. It may even mean reserving your decision for a short while. This will serve to remove you from the stressors that may have triggered your instinctive reaction. Question your instinctive position. Ask yourself why and demand a proper answer. Because I did not believe the witness is not good enough. Why did I not believe the witness? Did I reject her evidence because someone who was dressed like that must have wanted sex? Did I refuse the father custody of or access to that young child because I knew that he wouldn't be able to care for a young child? Moving from instinct to reasoning may mean a slight delay in giving a decision. But as judicial officers, we are trained to give cognitive-based decisions. It should not therefore take that long once we have engaged that part of our brain and ask ourselves the right questions. A reasoned decision that takes a little longer to deliver, but is far easier to defend to ourselves and to the litigants, and in the event of an appeal, than a hasty decision based on a gut feeling. If time does not permit a short adjournment, stop. Take a breath. Take a bathroom break. A sip of water. Anything that will allow you some time to engage your rational mind. Stick to the evidence. Ensure that your decisions are based on the evidence before you. Avoid generalizations. Be wary of relying on stereotypes under the guise of taking judicial notice. While judicial notice has its place, too often we use it to disguise slipshod decisions or decisions based on personal preferences or stereotypes. Turn it around. Exchange genders. Consider whether, if the person were of a different gender, would your decision or reaction to them be the same? Was your displeasure directed towards a very aggressive female attorney? If the attorney was a man, would you have the same reaction? Consider this factual scenario. The husband and wife have 3 minor children. Both husband and wife are permanently employed and in receipt of salaries of approximately the same range. The wife now has 3 other children and is living with the father of those children, who is himself gainfully employed. By consent, the husband was granted custody of the children of the family. He does not want maintenance for the children from the wife. Would you seek to persuade him to change his mind? Would your position be any different if the positions were reversed? There is no right and wrong answer here. The question really is, what would you have done in the circumstances, and would you have done the same thing if the roles were reversed? This is a true situation, one that we have used in training, and one which engenders a lot of discussion. Give proper reasons for your decision. Sometimes we give decisions which in fact are not the result of some inherent bias, but could be interpreted as such. It is our responsibility to the administration of justice in those circumstances to say what prompted the decision. It also serves to force us to look at that decision carefully, and thereby ensuring that the decision is not simply intuitive thinking. The fact that if we know we have to give proper reasons for each of our decisions, it requires us to move from intuitive thinking to reasoning and has the added benefit of explaining to the litigant why we made the decision. Training, training, training. Research on the elimination of bias tells us that exposure to members of unfamiliar groups can facilitate understanding, decrease bias in the use of stereotyping. At first blush, this may not seem to be relevant to gender bias. We have been exposed to men and women throughout our lives. But what about those persons who do not fit into that binary scheme? The intersex, the transgender, the non-binary or genderqueer, or the gay woman or man who does not fit into the roles, behaviors, and attributes that society attributes to their sex. There can be no gainsaying that in some of us, these persons evoke violent, instinctive, negative emotions in which stereotypes abound. As sitting judges, we live in a bubble for good reason. But it is not always possible to expose ourselves to members of these unfamiliar groups. What is not possible individually can be achieved by group training. Exposure to unfamiliar groups through judicial training is a safe and foolproof way of facilitating understanding, and through that serve to debunk many of the associated stereotypes and our inherent biases. The principles require us to have continuous training. It recognizes that there is a need for us to do so. They recommend the establishment of judicial training institutes in each of our territories. Indeed, training in gender is one of the areas specially referred to in the principles. It is recommended as an area of training that ought to be offered in every orientation program for new judges. But what about the older judges? Those of you among us who are judicial educators know the difficulty faced in attracting male judges, particularly the older male judges, to any training that has the word gender in it. The fact that you have all joined this webinar today tells me that I'm speaking to the converted. And as the converted, it is our responsibility to convert the others. In Trinidad and Tobago, before finalizing our gender equality protocol for judicial officers, we engage in consultations with judicial officers at every level of the judiciary. These consultations reveal two important viewpoints. Considerations that need to be addressed in any gender training program for judges. 1, gender is all about women. And 2, gender training has no relevance to the day-to-day job of judging. It is important, therefore, whenever we are embarking on gender training, that we emphasize that gender is not only about women. All human beings ascribe to a gender. Even those persons who describe themselves as gender neutral or gender non-binary. It is not that they have no gender, but rather their gender is neither exclusively male or female. There is a reason why gender discrimination has traditionally focused mainly on women. It is simply because historically women are a vulnerable group and therefore more likely than men to be the subject of discrimination. But it is not always so. A survey done by Eurofound in 2018 entitled Discrimination Against Men at Work, Experiences in 5 Countries, revealed that although overall women were the subject to greater discrimination in the job market than men, in areas which dealt with caring and nurturing, men were in fact more discriminated against than women. It's not surprising given the stereotypes. Another example more relevant to us as judicial officers is the discrimination faced by men with respect to the custody of children, and in particular young children, or the discrimination faced by persons whose gender does not conform with our idea of normal. These are all aspects of gender discrimination that arise out of gender biases. But what of the query that gender training does not relate to the day-to-day job of judging? When we started this discussion, we began with the principles. That is the answer to the question. As a judge, we are required in our day-to-day judging to avoid discrimination, to eliminate gender biases and stereotypes and the use of stereotypes. The thought that gender training has no relevance to our day-to-day adjudication is therefore plainly wrong. When we embark on training of judges, this is the argument that we must use to combat those skeptics that tell us that it's all irrelevant. Another reason why gender training is important is that it gives us the tools to deal with discrimination and bias against other vulnerable groups. Based on the Mexican model, the Trinidad and Tobago Protocol advocates gender-sensitive adjudication. That is adjudication employing a gender perspective. According to the protocol, gender discrimination is essentially but one manifestation of the power structure that evolves from differences in status of persons coming into contact with each other. Using a gender perspective when judging is simply a means of ensuring that the principle of equality governs our adjudication. As judicial officers, we can use a gender perspective not only to address and correct structural and systemic inequalities that arise as a result of sex, gender, or sexual orientation, but wherever there are power imbalances that result in structurally unequal outcomes. These structural and systemic inequalities can occur in a myriad of situations, encompassing all areas of the law and society. A gender perspective, therefore, is applicable across the board to correct these inequalities and a useful tool for judicial officers as we seek to provide justice. I think I can do no better than to leave you with these words. Thank you.
Thank you very much, Judith. This was a very interesting, a very thought-provoking presentation. We are extremely happy to have you with us today. We knew that it was going to be great. We didn't know it was going to be this great. So thank you so much. I just wanted to remind participants that if you have any questions for Justice Jones, for Judith, please use the chat function to ask your questions. And maybe to start the question and answer portion of our webinar, maybe I could start with one question from our side. So maybe you could elaborate a bit further on what are some of the characteristics of an effective gender training? Because from everything that you presented today with us, it really is about also a journey of self-discovery for a lot of the judges. When you're talking about unconscious bias, unconscious stereotypes, it goes deeper into the minds of the judges. So how to structure a training that can address all of these issues and really affect behavioral change in the judiciary? I think the first thing that we need to realize is that there are many facets in gender training. We in Trinidad and Tobago, we have
scheduled 4-day trainings to introduce judges to gender. So yes, we have to deal with the question of bias, but we have to deal with the question of looking at cases in a particular way, of identifying, where people are more vulnerable and applying the thought process there. But we also need to teach judges how they can, in fact, adopt international protocols, international treaties into their judging, because in a lot of times our domestic legislation doesn't always provide for the protection of these persons, of these vulnerable persons. So a lot of the training is also with respect to using the international protocols to our advantage, using the theories and positions taken there and bringing it into domestic law, even where in circumstances the treaties have not been incorporated into our international law. The other thing that we find with gender training is that because it is so close to us all, sometimes it is important to use games, to use let's deal with games first of all. To use games which allow people to relax. They actually live the position. They take positions that they will not necessarily take in discussion, but it's almost like allowing them to give us their instinctive position. And we find that when we do that and then have a debriefing on it, it helps. The other thing, and I touched upon it in the discussion, is diversity training. I think it's extremely important, because as judges, we just can't go out into society and meet and greet people very easily. So we become judges, we stay in our little halls of justice, we deal with people, we deal with our immediate family, we deal with people who come before us just as litigants, but we really do not understand the society. So one of the strengths of judicial training is that we can bring the society to the judge in a controlled and a non-individual atmosphere. I think basically that touches on most of the important aspects of training. I just want to kind of to emphasize though that as indicated earlier, one of our difficulties was and is attracting men to the table. So that is one of the reasons why I started the presentation with the principles. It's not that this is, some airy-fairy thing that women are trying to force on men. The fact is that our codes of conduct require us to understand gender and to apply gender-sensitive adjudication to our work. It's part of being a judge. And I think that, to my mind, is one of the most difficult aspects of trading. I'm hoping that this discussion here brings home to non-female judges that gender is all of us. At least half of the population is not of your gender. And so it must affect our judging. It must be relevant to our judging if we are to be relevant to the society? I hope that answers the question.
No, that's a very good answer, and I'm very glad that you touched upon the principles, the Bangalore principles of judicial conduct. As you know, we have developed in the Global Judicial Integrity Network a training on the Bangalore principles. We have an e-learning course and a self-directed course available on our website. And one of the topics that we covered there were the gender-related issues, because the Bangalore principles, they offer a very good framework under the principle of equality, but a lot of the issues that we're discussing here are not fully covered there, and we try to address this in our training. So maybe this is also another good resource that judiciaries, judicial training institutes can use. And I really like that you touched upon the point of the difficulty in bringing the male judges to the discussion. As you recall, and for those who didn't participate, Judith was also one of the participants in the expert group meeting that we organized in Seoul, in South Korea, in December 2018 to discuss the development of our now knowledge product, the paper on gender-related issues in the judiciary. And you'll recall that one of the difficulties that we had was actually in inviting male judges for that meeting. It was also one of the discussions we had there. So maybe this can link to one of the questions we have now in the chat, which is
Roberta, perhaps you moved to another question. I just wanted to say that one of the other things that we find is very useful in our training is in fact dealing with practical experiences, telling judges, giving them tips which would allow them to operate in their day-to-day judging. So that's another strategy that we find works. Yes, I'm sorry. So let's go to another question.
And I think you've already even covered the next question, but it's also very nice the point that you raised about the different teaching techniques that one can use in a training. You mentioned games, but also role playing. This is also something that we covered in our trainer's manual for the judicial trainers who would like to organize trainings based on the Bangalore principles. So it is important to adjust the training to the training preferences of each one of the participants, and it's helpful in a way, especially when you have different groups in the same training, maybe senior judges, junior judges, male, female. So you're aware of these differences when you're organizing your training, so you can address this in a way that everybody feels like they can contribute and participate in the training. They're not being targeted, right?
Yes, exactly. And once judges feel comfortable, then we really get to the meat of the problem. I mean, one of the things that we recognize is that particularly when we use games, positions are taken there that people will not necessarily raise as a question or as a comment in discussion. You know, people, because we are more relaxed, because we are having fun, you know, we can use that as a tool to promote thinking and make people ask themselves questions. Sometimes it's not even necessary to debrief, because sometimes people go back and say, well, why did I take that position? You know, so that we find that what we call icebreakers are really strategies to, I suppose, break ice to the person themselves. You know, you start now thinking of your self-examination starts.
That's true. No, thank you. And I think you just covered the question we had in the chat, which was about how to convince others to do this without being styled as a judicial activist.
Yes, we have that problem.
Yeah.
You know, so particularly as a woman, you know, you have that problem of are you pushing the woman's agenda? People fail to realize that it's not a woman's agenda, it's an agenda, a humanity agenda. You know, as we deal with human rights, as we feel that that's straight law, gender is also dealing with law, probably more so than ever, because, as I say, you're dealing with at least half of the population.
Yeah, exactly. It is a matter of human rights, and judges are the ones who have to uphold human rights treaties and regulations and laws. Another question we have here is, do you think there should be periodical evaluation on gender bias thinking and gender bias retraining?
Yes, definitely. Yes, yes, yes. The point is that training is for a time, and we work 24 hours a day. It is very easy for us to slip back into bad practices. It is very easy for us to sit through training and really not absorb the actual message. I think what we need to do is, first of all, ensure that our whole judiciary is trained. You know, and for jurisdictions that have mandatory judicial education, it's a lot easier. We don't. In our jurisdiction, perhaps the thing is to ensure that when we do the orientation, this is a component, and then you provide the training regularly every so often, because the reality is that gender norms change as well. What might have been, look at poor little Roosevelt, you know, we no longer wear skirts, men no longer wear dresses. You know, things change, and training must keep up to date with that. The other thing is that I think the tool of examining your decisions really is something that could keep you on the straight and narrow. You know, if there's a periodical, it doesn't have to be you alone. It could be that the judiciary commissions that exercise every so often, so that we ensure that we are maintaining a position with respect to gender and diversity. So
No,
hopefully yes.
No, I think that would be very helpful. And maybe this also links back to the point you made in the example you gave about the court staff that was discriminating the witnesses, that it shouldn't be just for the judges as well. It
Yes.
should be for all the staff court, all the judges, everyone in the judicial system, because it's everyone's responsibility to eliminate gender bias and stereotypes, right? So
Yes,
we have another question here. One of the participants is asking that in his jurisdiction, the Institute still finds it very difficult to conduct a fully fledged training on diversity for the judges. The issue is always court responsibilities. Any ideas on how to address that?
Yes, that is one of our pet peeves in judicial education. You know, the meeting the responsibilities to the litigants, to the public, in sitting in court, and also judicial training. The reality is that if we are not trained, we're not going to provide proper justice. So that at some point in time, we are going to have to accept that part of our responsibility, as the principals say, is to be trained. That is part of our day-to-day job. Once judges bear that in mind and start to realize that taking a day off from court to be trained is not a vacation. It is, in fact, giving you the equipment to perform properly. I mean, I don't think anybody will object to a doctor going to be trained in new medical developments.
Mhm.
It's no different. We are dealing with people's lives, and we need to be, as I say, we need to be relevant. We can only be relevant if we keep up with training, if we keep up with the changes in society, because that's what's happening. Life is changing rapidly. And if we sit in our little courts, in our little halls of justice, and think that things are going to be the same forever, we are soon going to become irrelevant. So training is absolutely necessary for our survival.
And as you also mentioned, the sixth principle of the Bangalore Principles, the competence and diligence, one of the obligations of the judges is also continued education, to continue to improve and strengthen their skills, and that should not knowledge of the law, the formalities of the law, but also all of these aspects the judges have to take into consideration in the adjudication process, right? So maybe another question. In training and in the trainings that you have conducted yourself, approach to deal with participants who stand very firm in stereotypes about gender roles. So how to deal with trainees who take the exposure of their biases very personally, for example.
Yes, I've lost some of what you said, Roberta, but I think you're speaking about persons who hold very, very firm and strong beliefs in certain things.
Yes, if they very strongly believe in the stereotypes, in a culture of bias and stereotypes, how to deal with in the training.
All right. So the first thing I think that we do and we need to do is realize that some things we as judges cannot properly teach. Some things we have to bring in experts to teach. Sometimes stereotypes and the use and we need somebody who is actually experienced and trained in teaching that topic. The other thing that we find is that training in a group, peer pressure. Peer pressure really makes a difference. Again, I go back to the so-called games, where people may say nothing in a discussion. Somehow we find that in the games, they are more relaxed, things come out, and it is easier for us to deal with it then. A debriefing, an example, it's we find that training in groups, particularly in groups of mixed levels of the judiciary, certainly helps. For example, being trained in a room with appeal judges who take a certain position will certainly influence younger judges in two reasons. Their judgments are going to the Court of Appeal. Also, they want to aspire to that position. So using different levels in training also helps, and that and peer pressure actually works. Again, of course, the other thing too is that we also have to continue testing. We have to do surveys. We have to see where we are at a particular point in time, because it makes no sense training and say, all right, we've done gender training, bye, let's go to some other training. We need to ensure that the training works. We can ensure that sometimes by surveys. We can ensure that by examining the judgments that come out of that court. And of course, to some extent, the court hierarchy also assists.
No, that's very interesting, and the use of peer pressure, especially how to work that to the advantage of advancing gender issues. It's certainly very interesting. And for anyone interested also in our trainer's manual, we'll also identify a lot of these training techniques and training styles that judicial trainers can use. And it's also very interesting, the point that you touched upon, that it's not just about one-off trainings, it's about continued education, and it's also about assessing the impact of the training, right? So it shows that there should be some longer-term planning from the judicial training institutes or any other bodies training judges, so that the trainings are included perhaps in a longer term planning of the activities for the judges. So the assessments of not only the internal gender assessments and the retrainings happen, but also the impact assessments of the trainings, right?
Yes.
Good. Well, I don't think we have any other questions in the chat. I think that you cover so well so many of the topics that we have now concluded all of the questions. Thank you very, very much, Judith. It was an extremely interesting session with you. Be sure that we might be asking you again to participate in other webinars, if not to go deeper in this topic, but maybe also in other topics that I know that you're also very passionate about. So thank you so much. And yeah, if you would like to say any.
No, I just want to say thank you very much for the opportunity. I think that, as I say, it would be wonderful if we can continue this webinar series for many other things, but it just is an easy way of getting judges from all jurisdictions together and discussion, because I think that's, we are always in each community a very small set of persons. So it's always good to be able to reach out to others and understand that our problems are not unique and that there may be solutions out there that we don't know about. So thank you very much, Roberta, and I would be willing to assist in any way possible.
No, thank you. And that's really what we are trying to do in the Global Judicial Integrity Network, to really create opportunities for the judges to share their knowledge, share their the challenges that they face and the solutions that they are coming up with, because I'm sure that there are a lot of lessons learned that can be, if not fully replicated, can be a good inspiration for everyone. And I'm sure that your lecture will be one of these very great resources that will be added to our website. For everyone who joined us, the video of the webinar and the presentation will be available on our website very soon. And also stay tuned for the next webinars. We will continue this series of webinars in June. We have already planned one on June 11 on the subject of the challenges to the judicial system in the face of the coronavirus crisis, judicial independence and integrity as the guarantees of the rule of law. This webinar will be in Spanish, but after that, we'll also have other webinars in English and also in other languages, so we can promote multilingualism and even expand the opportunities for knowledge sharing. So again, thank you very much, Judith. I wish you a very good day. For everyone who joined us, thank you for your time, for being with us, and we will see you soon in other webinars of the network. Thank you so much.
Thank you. Okay, bye.
Bye, thank you.